Well, if I may just start this session with a quick recapitulation, if I just ask you, so what's top on your mind of what you heard of and what you learned of the previous sessions? So could the three of you very, very just quickly just let us know what is top on your mind, what has stayed in your mind through the session? Just one or two words, terms, whatsoever that has just stayed with you.
I think for me in the PCT session, like how he said, I'm aware of, not too knowledgeable about the patent aspect, but the whole thing, the process was very interesting. And like how he said, you have to keep the timelines in mind and those kind of things. And even for the first speaker, Dr. Shivani, I think the patent search, what aspects to look for in a patent search, and I think that was top of the mind for me.
Lovely, excellent. Deepak ji, how about you? What stays in your mind? Okay. How about Harshit? Harshit, are you there?
Yes, ma'am.
Yeah. So Harshit, tell us what still remains. What's top on your mind?
From the first session, the various kind of searches, the various softwares from which the various websites and stuff from which we can do the pattern searches and how to conduct the searches, that stays, and the timelines that were told by sir during the second session by Piyush sir. I'm correct. That has also stayed. It's quite interesting.
Very good. Very good. Thank you. Thank you so much. Probably we are not able to connect with Mr. Deepak, however. So now we have another really, really interesting session on a very important techno-legal document of patents, which we call as specifications. Patent specification is a very important subject when it comes to the area of patent practice. So here we have Dr. Pradeep Kumar, who comes with an excellent profile, a very comprehensive profile, I would say, in terms of, and a very rare professional who comes with a science and technology background, but has worked in the area of management and is also a legal professional. May I have the privilege to just, give a brief introduction of Dr. Pradeep. So Dr. Pradeep is a registered advocate at the Bar Council of India and Bar Council of Delhi. He's a registered patent agent and has a collective professional experience of more than 21 years as far as teaching, research, and IP is concerned. He holds a master's degree in biotechnology and management, and also a PhD in biomedical science. He has really rich experience in terms of drafting patent specifications, patent analysis, gap analysis, freedom to operate, due diligence in patents, etc. He specializes in patent appeals, opposition, infringement, revocation, and any other contentious IP matters. So at any stage of the IP protection, of the patent protection, Dr. Pradeep is here to advise clients on all of these matters. And he is involved in advising on techno-legal aspects of all of these IP matters as far as domestic and international clients are concerned. He has been a reviewer of cardiovascular diabetology and for the Indian Council of Medical Research, Government of India, research project proposals, IP consultant with CSIR, and he is also a recipient of the Young Investigator Prize. So welcome, Dr. Pradeep, to this session, and we are really excited to hear from you and learn from you of this really very important subject of patent specification. Over to you, Dr. Pradeep.
Thank you, Dr. Pratima. That wonderful and nice introduction of myself and also the topic which we are going to discuss right now. And with that, I also welcome all the participants who are there in this seminar. And I hope that they would be learning something, at least something from it. And for that reason, I would be trying to keep this presentation as in a informal format, wherein we can go vice versa discussion, the queries which you have regarding it, and any other thing which you would like to discuss, and we can switch it to the presentation mode anytime you want it. So I hope it's okay with that.
Sure. Perfect. Pradeep, please feel free to share the presentation also so that we're running through that.
Right. Sure. I just start with that presentation also. So, okay, I just try to have an idea about what exactly, is it clearly visible? The presentation is there? Or uh, Dr. Pratima, you are muted.
Yes, it's clear.
It is visible.
Okay, okay, perfect.
Well.
So basically, first of all, we must know about the what is the techno-legal aspect of this specification. So to keep it simple, or rather, we must understand it in a very simpler sense. We must not take it at that it's something very complex or something like that. So may I ask a question that I think all of you must have been at some point of time has drafted some letters or reports or proposals, project proposal or something like that. So that is the most common thing which I think all of must have done it. So may I have a bit of idea that what exactly the important points which we must keep in mind while doing so, or if we are communicating with some new friend, we are just introducing some giving some details to him that we want to have this business collaboration with you, and these are our unique uh, points in this, and these are some key features which we would like to highlight. So all these things. So may I just have a quick uh, uh, thought from all you that what all would you be requiring to introduce into those letters or proposals like that? Very, very, very random thing which you think that it must be there. Anyone?
The subject and the details of the subject being discussed.
Yes, yes, perfect. That's perfect. Means essentially we must introduce what we are trying to convey and the details of all that what we are saying the subject, and that is it. Yes, perfect. So absolutely, that's one of the very good key feature for it. So as I said, we will be trying to understand what is this techno-legal aspect of specification. So basically, in simple words, we say that it's simply something which we give it to the other with the complete information. So we must write something with the exact thing. Now it has been set with techno-legal. It has two words which are imbibed therein. So techno means basically when we talk about the patents, they are technology or inventions. So that is where the techno comes. So it must give a brief, the details of that technology, what we want to describe. Legal aspect. Now there's another word that is a legal. Now the legal angle is because the patents are required to meet certain conditions, and those conditions are very well prescribed. If these conditions are not met, we may run into troubles. The patent may not be granted, and that's why that part which we uh, keep in mind to comply with those requirements makes a legal obligation to it. So that's it. That's why it's called a techno-legal documentation or techno-legal aspect of the specification. I would like to also give another example for this. Say, for example, if you are going with a contract, I think we are using contract in many different forms in our lives. And everyone has, at one point or other point, must have written or agreed to some contract. So again, when we write a contract, what does it mean? We write to give the all the conditions which may have certain implications or which are required to be met or which may be performed by the other party, and all those things. We try to give it a very importance to all those points which are indicated there in that contract. Am I correct or not? Or anyone has some other thing that, okay, no, these are not required in the contract? Or anyone can add it to what are the things which are required in the contract? Yes, please. Please feel free to add up to these things, because that's how we understand better why this techno-legal requirement has come up. Okay. So I'll just try to explain. Yes, yes,
Yes.
please.
Also, they bring definiteness to the whole contractual relation to the between the parties. So there has to be more definiteness and clarity. It brings more definiteness and clarity.
Very well said, Dr. Pratima. You are definitely on the very correct understanding of this thing. So exactly, we have to be very precise about the things, and the preciseness is not about our disclosure. The preciseness is due to the requirement which are meant to be met by this contract. So the patent specification, if you see, it's a you can say it as a type of a contract also, because the basic idea which is underlying the patent system, it is in exchange for a limited term right to exclude others from making, using, or selling an invention in a country. The patent applicant must provide, according to the law of that country, a complete and accurate description of the invention and definite in a set of valid claims. So it's a, like, otherwise it's a form of a contract. The contract says that you disclose the entire detail of your invention and get a protection for 20 years. And that these conditions must be met by both the parties. We want protection, but we do not disclose the invention. So the contract goes invalid. It cannot be met, or it cannot be completely satisfying all the conditions. So what does it indicate? That the complete disclosure of the invention should be there. That is from the inventor side. Based upon that, the protection would be provided for the 20 years. So this is very basic premise of the entire patent system. And to have compliance to these requirements, that is, the disclosure is made in complete and accurate form. What is the implication and how it affects the patentee itself or the applicant itself, that we have to understand. For that, there are certain prescribed sections or prescribed statutory requirements which are laid down to clearly guide the patentee or the applicant or the innovator to define or draft its invention in such a way so it meets all the requirement and it complies and it is suitable for a patent grant. So the other thing is, this provides other with the ability. Now, what is the reason that why must be disclosed? Because the concept is that this provides other with the ability to use that information to invent further, thus pushing the technology forward for the benefit of society. So if we say that, okay, this is my invention, and we do not disclose the invention in a proper context, the other party here is entire public, anyone across the world. So if the other person, any person reading that disclosure is not able to perform it or not able to reproduce the invention, he cannot use the information. So basically, the first requirement originates from that it should be complete and accurate details should be given. And that is for the reason that the other person can use it. So only then you are entitled for it, for 20-year protection. Thus, a patent is a written description that enables anyone to make and use the invention without too much experimentation. These are very basic fundamentals about the techno-legal aspect of the patent specification. Now, when we go with it, again, there are different things when we are in the process of the patent development or the coming with the innovation or creating an invention. So that involves the problem, a solution to that problem, and that is which is identified in a specific format is called invention, and that may be patentable. So problem is not patentable, solution as such is not patentable, but solution in the form of usable format is patentable. So it must otherwise also comply with the other requirement which you people must have already been aware of. That is the novelty, non-obvious industrial applications. So, and the benefits arises therefrom are that it prevents other from copying the invention, can be licensed to other agreed parties, public gain the knowledge of technology development, and technologically improve products benefits the society. So all these things, basically, as we said, if the disclosure is not complete, all these terms would not be satisfied to an extent. And that means the patent, although it may have been granted, but it may be revoked at any point of time, or it may be invalidated by taking up those grounds. So that's the importance. If we say it is common to observe that many times we find that the patent has been invalidated. or the patent disclosure is not enabling. So it's another term which we say enablement. So enablement is something that the disclosure or the patent specification itself is sufficient for any person who reads that disclosure, by reading that disclosure, to perform the invention. If he is not able to do so, what does happen? He will say that I am not able to perform, and this patent doesn't meet the basic requirement. Because we go back to the first requirement. You make a full and complete disclosure, you get a protection over it. So we normally, person or the inventor only see that they have an invention. They doesn't think it from the viewpoint that this invention disclosure, when drafted, should be in viewpoint of the other persons who is going to read them. So that's why I initially posed one question that how do we draft the project proposal or some reports or some letters where we have to clearly convey to our someone a very important thing to someone else. So in those situations, we take all the precautions, we give all the details. But while doing a patent application, this thing is not there in mind of many persons, and that's where the gap arises. So these are some questions which must be very, very, very clear in the mind of all those who are going to draft. So basically, the techno-legal aspect is entirely dependent upon, or it goes down to the drafting level of a patent specification and how does the drafting has to be taken up. But before going to these questions, I feel that it's a post-lunch session. So I would like to take you into a small video. You watch it for just 1.5 minutes or so, and just try to identify that. I will be asking a question based upon that in the end of this session. So hope many of you must have seen this video.
Dr. Pradeep, is the video play?
Yes. Is it not coming there?
No, we can see only the link for the
link.
YouTube link.
Okay. I just try to, maybe it was the only link was there in presentation. So I think it's not capturing that.
Yes.
You can click it into the chat box. I think that we can see.
Okay. Just a
No,
minute.
it's shared on screen, but you'll just have to shift the screen to the video link.
Is it there or not?
No, we are
No,
not.
it is not there.
Okay.
Probably you can stop screen share and then just get to the link, specific link.
Okay.
Now just try to do the screen share to the video, and then we can come back to the slide presentation. Or would you like to just share? Yeah, we can see. Yes.
Right. It's there. Okay, sorry for that glitch. So I am just adjusting it.
And I think there's also an option available for voice sharing.
Okay.
While you are sharing the screen itself.
Okay.
We're unable to see we're not able to hear it.
Okay. So voice is not coming, I think.
Yeah.
Okay. So anyway, means there's no only the music, background music is there.
All right.
So it just to give some agitation to the mind of the participants.
Yes.
And to understand, because they must have been, or I am sure that they must have at some point of time viewed this video or similar videos. So I'm skipping some of the portion. So it's now going in a reverse orientation. Okay, so I think that's enough for this particular concept. And I think I'm audible there?
Yeah.
Right, okay. So I'm just going back to the presentation. Okay, so you have just that short video. Basically, the point of sharing that video was just only to invoke your mind to think about, and whatsoever thing which comes to your mind, just keep it noted down on in that some piece of paper or to your mind, and just we can discuss it, that how this particular video clip is relevant or have some significance with relation to this particular topic, what we are talking about. Because this gives us a very important insight when we start from down from the very molecular level and go to the cosmic level, and there's an entire this transition. So that is something which has been depicted in that video, and so just give a thought over it. So how it is, it can be correlated to the present topic. So next, we will see that when we go down with these technological requirement, so one must be very much clear about all the things what we want to convey to other, and so we must make some check boxes and while drafting and all those things. So these questions should be there should be a very clear answer to all these questions, and some of these questions are just for your benefit, has been indicated therein. So did you or anyone else make a written or oral publication disclosure regarding any aspect of the invention? So this leads to a very clear answer that if the answer to this is yes, then that may have some issues into the novelty part. So that's how, because if we in the our draft itself says that, okay, this is the published on such and such date, so that gives an indication that, okay, this is already a published work. So always the invention, we must satisfy certain set of criteria for which the patent applications are being granted. And all those criteria are basically being identified, whether these criteria are met or not, they are being identified by the draft, the specification. So your invention itself must identify that this is the uniqueness. We say that an inventor has developed a product, but he doesn't define it in a unique way, or the unique feature of that invention has not been defined in the description. But he says it's a novel, no one has did it. So how does the other people come to know that it's a novel, or what's the novelty about that thing? What's the unique point about that? So that should be clearly there. So next, does the application describe the invention in a manner that invention can be carried out? Sometimes we say that, okay, we believe that it is something which can be worked out. Maybe this product is very wonderful product, but I haven't manufactured it yet, but this will be a very useful thing. So if the entire description is written in something like that, so it is going to jeopardize the entire concept of the patent. Does the application describe what exactly have been invented and what problem known in the art is solved by it? So the problem solution is very much important. And to an extent, maybe at some point of time, the problem may not be at all be there. But still, if it is known that this particular problem was there and it has been solved, so basically it relates to its advantages. It totally depends on the type of product which is covered by the invention and what advantages it posed. Because the inventions are basically technical advancements, and the technical advancement means that either it should give some edge over the product which is known, or it must solve some problems which are known in the art. So either way, how we are going to establish this particular point. So all these points which must be clearly established by the specification, and that's the legal as well as technical requirement. The technical requirement, the legal requirement is met by the technical description. So is there any other way to arrive at the technical effect caused by the invention? So it talks about any alternative which we have. Does the application describes the advantage of invention in comparison to prior art? This is just, I discussed that it should show some advantages over the prior art. But sometimes we may just be saying that it is very good. It is better. It is performing better. But how do we say it? Can anyone tell me how do we say it that it's a better? How to say it is a better? Say, for example, we are just having an interaction. So maybe through this virtual platform. So we may compare some different virtual platform for the conference. Maybe on this simple term, I may say that the mic which I am using, there may be some better mic than this. But how you are going to say it's a better? That judgment comes from some There is subjective or very objective identification of certain feature. Say objectively, when we determine this is better, as I said, that mic may be better, so the mic, its voice quality may be better, distortion may be less, or the background noises may be very much eliminated. So this must be the criteria, and you will measure all these things, and then you will be say it as a better. Simply saying better doesn't make the things a better option. You have to identify how it is better and describe that. So unless these things are being described in the description, means we must not expect much positive things about that. So does the application describe the important and critical feature of the invention? In the very beginning, I said that the novelty part, we know the inventor says that it's novel. It's no one, because those things are in his mind. He must have done something. He must have added something new component to the invention. But how does the reader know? Because this document is not for himself. This document has to go to the public. And the public must understand that this is the new thing which has been added by the inventor. So once we understand this difference, that this document, the patent document or the patent application, is not meant for the inventor. It is meant for the public. And the public must understand what is in the mind, what the inventor has identified to be better, that the public must understand and appreciate. Only then it meets the requirement. Does the application describe how was the problem solved in the past? It's again a very important thing, because we say that the present application has solved some problem of the distortion in the voices in the mic. But that this solution must be coming from some changes in the mic structure or in the software or something like that. So we have to clearly pinpoint that we have added this software which reduces the voice distortion, or we have added this component in the mic system, so due to which the voice become very crisp. So anything which has been modified, that must be clearly brought in, that this is how we solved it. Simply saying that we have solved this problem and not saying, because the invention, basically invention is something which is tangible. It's a physical thing. And that physical thing, if the changes are occurring, its characteristic or its behavior are changing, those would be as a result of some physical changes or some even software changes. It may be there, but then the software is responsible for that. So anyhow, means the way the improvement has been brought in, that should be depicted. Now, another important question, how could a competitor design around and the contemplated patents claim? So this is very, very important thing which has to be always kept in mind. And accordingly, the claims or the description or the experimentation should be extrapolated and should be expanded to a reasonable values. This would, like say for example, it's a chemical patent wherein using A, B, C, three different components or the constituents in a certain specific amount, 5 gram, 10 gram, 15 grams. So now instead of we claim A in 5 gram, B in 10 grams, C in 15 grams. So the competitor may say that A in 15 gram, B in 10 grams, and C in 5 grams. So he may design around because we have not claimed that. So he may claim that. But the question again arises that whether this combination would work or not. So if this rearrangement or readjustment of the different component and their amounts would lead to some workable invention or not. So it has to be evaluated, and accordingly, the broadened range or the broadened structure of a product may be introduced to avoid that the competitor may design around. Say, for example, in a chemical invention, there may be a requirement of a solvent, or in a mechanical invention, a telecommunication device or a telecommunication system, there is an transponder. So the transponder is not our core invention, but we have introduced some frequency modulator which has changed it. Or in the same way, chemistry invention, we have used specific active ingredient which is responsible for the effect, but not the solvent. So we can say the solvent is to be any solvent, because basically the invention, if suitable solvent is used, the effect may be more or less same. Maybe slightly they will vary according to the solvent. Same way, if the transponder here itself in the mechanical invention. So leaving apart other components of the system, specific component may result into certain variation or differences. So accordingly, the non-essential components may be allowed with a flexibility so that the competitor may not design around. So this has to be kept into the mind. So does, again, another question, does the application describe what technical problem has been solved by the invention? This gives an edge, because if we have able to identify the problem and how the solution is afforded, it becomes a very easy to identify what kind of experimental data may be provided against the solution or the betterment which has been attained by the invention. So again, these are some basic questions which helps us to come up with a much more appropriate patent specification to comply with the techno-legal requirement. So in the last, we see, does the application describe what all technical effects have been caused by the invention? If we do not write the technical effect, maybe yes, in some cases, like it varies from field to field, that in certain field of inventions, the technical effects are more emphasized, whereas in some other fields, the technical effects are not that much emphasized because of their difficulty to prove those technical effects. I give you very broad example. Say, for example, there's a civil engineering related invention, and the invention is related to construction of a dam, a reservoir. So in that, the dam reservoir would be a huge structure which would take some 10 years to build up, or at least 5 years to build up. Huge investment would be there. But if it has a unique design which has been created into that, so eventually this is going to be practically implemented. So, and that shows that by some other statistical method or certain other computational method, it has been showed that this particular reservoir structure would be much more stable, or maybe stable to the earthquake and all those kind of natural disaster kind of situations. So maybe in that, the data may not be that much required, because the structural changes in that component itself may suffice the thing. But when it comes down to the pharmaceutical patents, which are quietly not allowed before any clinical trials and all those data are being submitted, and the approvals from the regulatory authorities has been obtained, in all these kind of invention, it becomes very much essential to show that the technical effects attained has been clearly demonstrated, because an existing solution to a particular disease or a particular state of human or any other animal, that may not be much benefited by an alternative. And the other alternative which a person may be attempting to claim in that invention on the basis that it is novel, and giving a statement that it may be having a better effect, better curing effect. But if that curing effect has not been demonstrated, it may not likely to be recognized inventive. So it is very much important that the technical effects has been shown and in the description. So this is something which we have already understood, I hope, that in general sense, the document provides a disclosure of invention carried out by the inventor and wanted it to protect. The disclosure must be full and complete. The disclosure must be such that a person skilled in the art should be able to perform and reproduce the invention without requiring any undue experimentations. Claims with well-defined boundaries, identifying the scope of protection afforded by a patent document. So one part we have emphasized or discussed so far, that is what kind of description should be there in this specification. The other very much important part of the patent specification are the claims. Now the claims are basically the elements which identify what we want to protect and what scope they would be affording us in the protection. So they should be very much carefully drafted. The use of expression or use of something, use of the additional features, use of any preamble of the claim. How do we give an example in that? The properties which we introduce into the claims, what effects would be having by using the different expression in the claim structure. So all these are very much important, and based upon that, the entire patent can fail or can sustain the test of law. So coming down to these requirements, how do we sometimes check it out? We have said that these are some basic questions which must be asked and these must be taken care. But basically all these questions or all these requirement has originated from this. And to simplify that, whether these requirement, what we are trying to discuss, these are being met, more objectively, provisions has been laid down. So these provisions must be checked and by the drafter as well as the inventor, and eventually they are checked by the authority, examination authority, during the examination of patent application. Even after the grant of a patent application, these provisions, whether the patent satisfy the requirement of these conditions, are being evaluated during subsequent proceedings, the court proceeding, the infringement proceeding, the opposition proceeding. So these provisions should be always very carefully understood and compliance made to. Because if I'm saying that it should give a complete disclosure, that is something which is a statement which is given by me. But now the statements or the requirement which are raised in these sections, they specifically being understood and being complied with. So basically, if the condition which are laid down in these sections, section 10, which most importantly lays down the condition for the content of the specification, will be a sufficient guiding principle or guiding instrument to that what is the legal requirement to create a techno-legal document, that is the patent specification. So it says every specification, whether the provisional or complete, shall describe the invention and shall begin with a title sufficiently indicating the subject matter to which the invention relates. So in a short, this is a requirement which talks about that the title should be given, and the title should be such that it sufficiently indicates to the field which subject matter relates to. So it's much of a simplified requirement, but we still, this has to be there, that we create an invention which is related to some medicine, but we want to name that a novel drug for curing a magic curing drug. So magic curing drug means we are trying to introduce an element magic, which is something which is not definitive in this sense. And again, a magic curing drug, it is, we are only indicating that it is a drug, but what kind of drug, what kind of condition it is going to treat, or what is its compositional thing, we are not indicating anything. So the title should more be relevant. Or we say, we just want to say that the inventor feel like that I want to name this drug, and he himself names that drug, the medicine, and says that I want to name XYZ, and I will be saying that XY medicine. So, and that's not the correct, because the people around the world, they will not be knowing what is XYZ. So next is, subject to any rules that may be made in the behalf of this act, drawing may and shall, if the controller required, be supplied. So in addition to the specification, there may be supplied the drawings, and these drawings are supplement and they are integral parts of it. As I said, that it is very much essential to elaborately describe the invention. So the drawings are something which very crisply and clearly conveys the invention. So it's not always there that drawings can be possible. It depends upon the invention to invention. So if it is some invention which is related to structural components, maybe a flask, or maybe some mobile device or PD or something like that, maybe a pen, all these drawings are feasible. But if we say the compound, so or a composition for the treatment of a particular disease, so what kind of drawings would be there? So in that situation, the structural arrangement of the different constant may be provided, or the data which provide the improvement that can be provided in the form of drawings. So it's always because there may be ambiguity in the interpretation of the language, descriptive language, due to some usage of some verbs and the adjectives there, and from a reader from from India and the reader from the US may differently have some different interpretation. It's quite possible to an extent. But if the drawing is given, there's no differences in the interpretation of the drawings. They are very crisply convey your invention. If that is possible, it is always the best thing to give an elaborate drawings. So another condition is there. If in any particular case, the controller consider that application should be further supplemented with a model. So this is additional condition wherein the controller may require model or sample of or any illustrations. Nowadays, it is rather this maybe in due course of time, this section may be itself amended, and it may be provided by the sample videos, or maybe an illustrative the videos which can explain the working of an invention or construction of an invention. So that can be for an easy explanation of the context. So now we come to the most important part, of which describes the legal requirement of a technical document, that is the patent specification. Every complete specification cell fully and particularly describes the invention and its operation and or use and the method by which it is performed. So this is a very, very important requirement. I think so far what we have discussed, we are always focused on this part, that there should be a complete disclosure. Now that all entire discussion run from this particular section, that is 10.4a, that is fully and particularly describes. If a person fails to describe the invention completely in the disclosure, and he just simply tries to claim it, the moment there may be some opposition or there may be certain invalidation, and the other party would be saying that I'm not able to perform this invention by reading the disclosure. He is not supposed to refer to or come back to the inventor or to the applicant, or go to a very top-notch scientist and ask for his advice that please help me in this experiment. He should be only having a basic knowledge, basic skills about the required in that particular field of invention. And by having that much of basic understanding and knowledge of the field, and by reading the disclosure, he must be able to repeat the invention. If one understands this requirement, I think most of the problem which are associated with this thing would be solved. If there's any question on this?
Well, I have a question. I don't know if I can ask you now, or if we could take it later.
You're always welcome. It's okay.
Sure, sure. This is very particularly about complete specification, right?
Yes.
Sometimes an inventor may just want to go for a provisional filing. And how comprehensive should this filing be? For example, I just want to discuss this with an example. Let us say the inventor has come up with a device which is more of a manual device, but he wants to automate this, or of course, develop it further. But for reaching out to investors or for any purpose, he wants to start. He wants to immediately get that priority date, but he can only summarize because it is still at an ideation stage. They have not really created a prototype. They don't want to waste much time till they, got a prototype of it. So in such instances, how comprehensive should the provisional filing be? And two, if this if the complete specification can add more features to the existing invention of what has not been provided in the provisional filing.
Right. So that's a very good question. And basically, like uh, for filing a provisional and filing a complete after that filing of a provisional application, the basically the provisional application should be filed with as much as possible details of the invention that should be given therein. And if and at least if the details are not available, the concept of those things, like broadly I say that what I cast from your question, that he want to automate and he doesn't have much of funding with him, so he is exploring to automate. So his core invention is being described there. A means to automate that invention may be described in that invention itself, that a suitable means to automate its functioning. And the suitable means may be selected at a later stage because he have not performed those experiments and may require some additional experimentation. So what kind of means he require for automation? So that can be elaborated. So basically the invention which is broadly defined, it can be elaborated to an extent, or it can be elaborated to a very great extent, rather I must say that. But if a new component, there was only a mechanical device, and that mechanical device has 4 components, those has been given. None of those 4 components relate to the automation. And now we talk about the automation in the complete specification. So that may be causing a problem. So introduction of a altogether new different component, which is not broadly covered in the provisional file specification, that may cause an issue. Because although this is not being examined to at a very depth and a very minute level, but basically the claims of the priority are basically claims. So what is broadly being claimed in the priority? So that's how it has to be understood, that at least we must try to give all the broad elements what we are trying to work further and maybe fine tune in the future. So I think that's the best way.
Yeah. So the scope of invention cannot be too varied in the complete specification. It has to meet the provisional.
Yes. So in a case wherein there's a variation, either there are another alternative which are available. Either a new application can be filed or a patent of addition can be filed if a new concept or new feature has been added. So the patent of addition always provide the flexibility of addition of new component to it. But as a PS to CS, because of course it may be done, and many times it goes unnoticed also in practice, in real sense. But considering the concept, the exact precise concept, because there may be a challenge subsequent to even the prosecution stage, the patent may be challenged before the courts, and or it may run out into some litigation due to infringement or some other matters. So in that situation, the priority claims would be evaluated more subjectively. And in that situation, if the other party is able to prove that these are important things, and most importantly, the additional component which we try to add on to the complete specification must not be essential. We must not rest on it, that this is if we remove that, our invention would not work. If we are adding some ancillary features, that can be done.
Got it. Thank you.
Yeah, thank you. So that's with the all focus where we have gone with. And now the B, that is 10.4b, disclose the best method of performing the invention, which is known to the applicant and for which he is entitled to claim protection. So he must disclose the best performing method. So this gives 2 things. One is that he must give a complete disclosure. The second is that he must give the best method of performing it. So what is the relevance of the best? The best method, that means it is going to ensure that it is going to work. There may be inventions wherein we claim it over a broader range. Some range may not work, but he must at least clearly disclose this is the best method and this is going to be the best range and this is going to definitely work without any doubt. So that's the relevance of the best method. The second relevance of the best method is that he has actually done it. This is another aspect which is being covered by this particular provision. Next is C, and with the claims or claims defining the scope of invention for which protection is claimed. So finally, the claim should be there, and that claims should clearly define the scope of invention for which protection is claimed. So here comes a very important question where many people find a confusion or are in a confused state. And I think there's some clue. And I think the video which I shared has something in relation to this. If any one of you can correlate, what is the correlation between this 10.4c, that is, and with a claim or a claims defining the scope of invention and that particular video. So just please let me know, just think about it. So that's just an opinion that how we perceive the invention. Right. So you can just note it down in at your end, and we can just come to that discussion at the end of session. So next is it should be accompanied by an abstract to provide technical information on the invention. So basically that's another requirement. So that is not much of a complex requirement. We have to summarize the objective, the field of invention, the problem solved, and basically what we try to claim. So that in a very summary form should be provided in the form of abstract, so that anyone who goes through abstract may be able to understand what is this invention is all about. Now, apart from that, there are certain situations in which the above requirement are raised to another level in a particular situations only. So the controller may amend, that is the first part, that is the discretion of the controller. The second part, if the applicant mentions a biological material in this specification, which may not be described in such a way as to satisfy clause A and B, and if such material is not available to the public, the application shall be completed by depositing the material to an international depository authority under the Budapest Treaty and by fulfilling the following conditions, namely, deposit the material shall be made not later than the date of filing or the priority date of application, and a reference thereof shall be made in this specification with the prescribed period. So this entire requirement is all about the biological materials. So we know biological material are of complex nature. Maybe we may be requiring some reagent. We may order it. There's a specific compound name. There's a specific means all things we can. They have some specifications, and they can be procured from the vendors or suppliers by ordering them. But when it comes down to the biological material, of course, these materials can also be provided by some vendors, but still they are much more complex than the other materials which are available. So say, for example, if we just say that we require a bark from a mango tree as a biological material. So as we know, there are different varieties of the different plants, and same is there for the mango also. The mango tree which may be available in India may be having different characteristics from which are available in some other part of the world. This is one level we have talked about. Now we go down to a molecular level. Maybe we may be taking a gene from a particular plant which is being used. So that particular gene means a molecule or a fragment of a DNA. So DNA there are a long stretch of a DNA, and we are only using some part of it. So it will not be very easy to say that this particular DNA I'm using from this particular plant. If I simply say it a DNA from the mango plant, so there are thousands, millions of base pairs of nucleotide long base pair DNA fragments. We won't be able to catch up. We give it in disclosure that, okay, this is something which I'm using it. But where the other person, because the entire specification is meant for the other person, other reader, who's going to read and recreate the invention or reperform the invention. So what molecule he's going to pick up? That is the biggest problem. So here it says, if the biological material is used, which may not be described in such way, if it can be described so that there is no confusion between the material which the reader would be procuring it and which I'm using it or which I'm referring to it, it's okay. There's no other requirement. But if it cannot be described in such a way, then that material should be made available to the public by depositing the material to the international depository as laid down by the Budapest Treaty. So it ensures that the material required to perform the invention is known to any reader, and that material he can procure it. Because I may be using a specific microorganism. That microorganism is only available to me. I may write in my description, a microorganism, this, isolated from this, having this characteristic, everything I have given. But the person who has to repeat this experiment and want to improve it, any public, so where from that person will get this particular microorganism? He won't be able to get it. The reason being, because that microorganism I have isolated from this specific location and I have maintained at my home laboratory. So in that situation, if I am referring that, okay, this is a specific microorganism, so I must first of all deposit this microorganism to the international depository and give an undertaking that this material would be made available to the public after the patent application has been published. And secondly, I must give the details of this deposition in my specification that, look, you want to perform this experiment? Okay, you can do it by procuring this microorganism from this particular international depository with this reference number on this date. I have deposited. You go and collect it and perform the experiment. So that is the reason why this requirement has been raised. If we do not submit it, the other public would not be enabled to work this invention. He won't be able to perform the invention because the biological material is not available to him. He will simply say, the description is not enabling because the deposition details has not been provided or deposition has not been carried out. How can I do it? So he is not entitled for a patent rights because there is no full and complete disclosure. So this is the importance of this particular section, which is proviso which has come up with the description or the details. And more important, that the deposit should be made before filing or before the priority date of the application. The moment we file, on the very same day or before it, it should be deposited into the international depository. Of course, that details like the reference number for the depositions or the deposition date on which the deposition has been made up, those can be incorporated in subsequent time. Within 3 months time is given there. These details can be incorporated into the detailed description. Next, all the available characteristics of the material required for it to be correctly identified or indicated are included in the specification, including the name, address of the depository institutions, and the date and number of the deposit of the material at the institution. So that's what I said, that these details should be indicated in the description. Access to the material is available in the depository institution only after the date of the application of patent in India, or if a priority claimed after the date of priority. Basically, this is to protect that no one is able to carry out your invention before the priority date by obtaining that material, because the deposition at depositories may be of different kind. If it is for patent, then of course they will be taking care of this particular part. Otherwise, the deposition can be there in which the deposited material cannot be supplied to other. You can ask the depositories for such kind of things also, that this material is only exclusive to me, and only when I request you, you provide me, otherwise don't provide to public. But when the deposition of biological material is with respect to the patent application, that is made available after the publication of the patent application. D. Disclose the source and geographical origin of the biological material in the specification when used in invention. So again, that's another elaboration or adding much more details to the use of the biological material, that where from it has been geographical origin and where from the biological material has been obtained, so that clearly identify. If we doesn't say that this particular gene has been isolated from the mycobacterium or maybe some other microorganism, and simply give the name of a gene there which may be present there in different microorganism, that won't give an accurate information. So the source and geographical origin are both need to be indicated when it's a biological material. So these are some of the important requirement of the specification, which we need to understand and should be kept always in mind while drafting, and so as to comply with that legal requirement, which are eventually reflected in different proceedings. And coming down to, as I said, there's a section 64(1)(h), and section 64(1)(h) states that patent may be revoked on the ground that the complete specification does not sufficiently and fairly describe the invention and the method by which it is to be performed. That is to say that the description of method or the instructions for the working of the invention as contained in the complete specification are not by themselves sufficient to enable a person in India possessing an average skill and an average knowledge of the art to which the invention relates to work the invention, or that it does not disclose the best method of performing it, which was known to the applicant for the patent and for which he was entitled to claim protection. So this clearly says, and this comes the after effect. If it is not done, it may be revoked based upon some proceedings are initiated. So at that situation, it would be again reassessed. So, and if it is not found to comply that requirement, that's why it's a legal requirement. It doesn't comply a legal requirement, so there's a consequence to it. So here it's a consequence which may arise in future. So on other end, when we see this is the core. What is the legal aspect of the patent application or the patent specification? On the other end, there are certain procedural or formal indications which are highlighted, that how the description should be there. And they themselves has their own relevance, all these, and these must be adopted for the completion of the document. That is the title. The specification must, or the patent application must have a title, a field of invention, the background of invention, brief description of drawing, summary of invention, detailed description of invention, claims, and abstract. These are the important parts of an patent specification. So here again, it's not essential that all the elements are very much essential, but they have their own role to play. And to some extent, like we can say the title is essential because that will be identifying it up. On other end, last we say the abstract, it is summarizing the invention, that is important. The claim, it's very important. Without claim means what protection we want to protect by filing this application. We are not submitting anything to that end. So that is important. Detailed description of an invention. This is very important. Other, like field of invention, still if it has been roughly indicated, that works around the background of invention, that shows that what development or what improvement has been added, what was known in the art. So that gives him some portion of an idea. This gives a very clear picture about your patent application. But these doesn't have that much of an emphasis that if these have some issues, the invention would go. But the core thing where the invention resides or where the invention is described is the detailed description of the invention. There are the example, there are working examples, there are illustrations, and everything is there in the detailed description. Description of the drawings may be there, may not be there. It depends upon the inventions, and if the other end, there may be no drawings at all. So again, that component becomes an optional, but it adds to the clarity of entire draft. So we will discuss all these elements in a very brief, one by one. Title should be very concise, provide the crux of the invention. The care should be taken that ensure that scope of the title covers the scope of the claims. And they must have some consistency, and the title should not be very, very specific. Specific in the sense it must not be related to its application aspect. Rather, the title should be identified to the core invention. It must be short and specific, may not exceed 500 characters in length, and typically it's very short and often similar to the claim preamble. The word like new, improved, improvement of all these should not be used, and should not be too general like capacitor, and cannot be a narrow than the broad claim. So basically, we have to identify the broadest claim and accordingly the title. The field of invention, it gives us more or less the details of the title, provides utility and statement of the field of the art to which the invention pertains, usually written as two-part statement, broad statement followed by a more specific statement. The present disclosure relates to the field, like if it is a chemistry related a pharmaceutical related patent, so we can just write it relates to pharmaceutical fields of pharmaceutical, or a field of medicine, and more particularly this relate to a therapeutic composition for the treatment of the cancer, like that. So it has to be the broadest field where that particular invention is found to be relevant. That should be indicated, followed by the more narrower fields. Specific statement should be at least broad as the broadest claim. Next comes the background. So the background provides the technical background of the invention by stating the known art, what is known in the art. And this gives an idea, basically this is a way to develop or to write the prior art. So the prior art should be what is known at the earliest and what is the latest known at the point of time when the invention was created. It's like a chronology. What was known in the past, later on how the development flew, and next development has happened this, and next development has taken this, and now we have developed this. And this, our invention provided solution to this thing. So that's how the prior art should be help us to identify what is the problem associated with each art and what solution has been proposed by us in the last. That is going to be the conclusion, but it's not like that. Basically, because that shows a developmental path for the invention, and maybe in a kind of breakthrough inventions, maybe there may not be a sufficient prior art to indicate that. So in that case, maybe this may be becoming a requirement which may not be of that much of significance. But still, to understand, to give the reader a clearer understanding about the invention or the creation or the innovation which has been contributed by the present invention, the background should be clearly given in a manner, so in a chronological manner of a development of that field. Next is summary of invention. This summary should be consistent with the invention as claimed. Track the language of claims in plain English sentence without legal phraseology like means or said. Avoid referring to objectives of the inventions. So the summary again gives its expression, or the terminology itself indicates summary of the invention. So if we are able to give the invention, the crux of invention in a small short paragraph, 2 or 3 paragraphs, so that can be a summary of the invention. Or in an alternative, the summary of the claims may be given in a shorter form, what is we are going attempting to claim. Brief description of drawing. Again, the drawings which are being appended to the description, that should be briefly described, wherein the reference numerals should be elaborated. Each embodiment of the figures or the drawings should be elaborated, what they are explaining, refer to an embodiment rather to an invention. Example, figure 1 is a top view, figure 2 is an exploded view, figure 3 is perspective view, and like that. So, and apart from that, the figure 1, there may be reference numerals which may be indicated, because the descriptive matter has not to be given in the drawings or the figures. We cannot say that there are different components, so we will not label them as by name of the components in the drawings. The labeling in the drawing or the figures should be indicated by numerals 1, 2, 3, 4, or ABCD, like that, and or Roman 1, 2, 3, 4. And those 1, 2, 3, 4 depiction should be described herein in the descriptive part, that 1 represent this particular thing, 2 represent this component, 3 represent this component, like that. So all that has to be given in the description of the drawing. Now the detailed description. Description sufficient to enable a skilled person to put the invention into the practice. Now again we go back to what we have already discussed. So basically all those requirements should be met by the detailed description part. Describe the invention in a greater detail with examples, illustration tables, etc. How the invention is performed, experimental details, best mode of the performing of the invention, all should be given under the headings of the detailed description. So basically this is a layout, that is the field of invention, summary of the invention, brief description of the drawings, and the detailed description and the claims. This is the layout. So it has its relevance in there, that this is the format which is being adopted, so as everything is covered up. But the core lies there in the detailed description, which has a very significant importance and has to be kept in mind by the drafter, the inventor, all times during the initial phases. The claims, the most important component here, because I would not say these are the only most important component, but one of the most important component, because the 2 components, that is detailed description and the claims, these goes vice versa, means without claims or claims without detailed descriptions are meaningless, and the detailed description without claims is again meaningless, because the protection or the evaluation or infringement or invalidation, anything that goes on the basis of the claims, what is being granted, the scope, what is being asked for in the claims. So entire thing hinges on the claim language. And the claim language is to be adequately, what is being tried to be claimed in the claim language has to be adequately supported in the detailed description. So the claims and the detailed description are 2 very important components. The claims define the monopoly to be conferred by the patent. And define the metes and bounds of the invention. Assessment of the patent application is primarily focused on the claims of the application at the time of infringement proceedings. Claims will be primarily interpreted. The main claim defines the essential features, and the subclaim define the preferred optional additional features. Consider writing independent claims for a system, method, and apparatus having a system. Dependent claims should be drafted such that they can be merged with the independent claims for addressing if required. If you don't, you disclaim. If you do not claim, you disclaim. So before going to that, there's a specific claim structures and claim format which has to be taken care in the drafting of an patent specification. I would just skip to another important slide and come back to you on this question. So is this visible to everyone? All the participants can view this.
Yes.
So yeah,
Yes.
perfect.
Yes.
Yeah. So I just give an example to all you there. There's an inventor who identifies that he has created an invention which is important for car batteries, and that is a electrolyte, a very important electrolyte he has developed, and which is to be used in the car batteries, and he want to claim. So now what a claim should be directed to? So that is my question. I think I must have a quick response to it from every participant to it. What should be the claim? I mean, just starting 3 words of that claims. I hope my question is clear. I mean, basically, an inventor has developed an electrolyte. Electrolyte is a component which is being used in the batteries. The battery is used in the power the car, right? So he's thinking that I have created an electrolyte which is to be used in the batteries of the car. So what should be the starting line of the claim? Just 3 words. Yes, can I have it from you?
Maybe
An
speedy.
electrolyte which enhances the efficiency of the battery.
Okay, thank you. Thank you, Arshit.
Maybe
Anyone
speedy.
else?
Yeah, speedy recharging of the batteries.
Speedy recharging of the batteries. Okay. Anyone else? Please come up fast. That will help us understand the core concept of this thing. Okay, so let me summarize into that and why my question was there. Because many times it happens that the invention is meant for the car. So many people will come up say a car with a something with a wherein the electrolyte is there. And maybe some other people may go with the okay, a battery for car. They may also come up with the claims in that sense, a battery with the car with the having that electrolyte. But more precisely, in the very beginning, my question I started with that he has developed an electrolyte. So the claim should be targeted to an electrolyte. So that electrolyte may be used in the car battery. That may be a secondary application, one of the important application rather, we may say. And there may be still other application which are not even known to the inventor. So to keep it like that, if he claims a protection over an electrolyte, which may be used in this car battery or maybe inverter battery or maybe solar batteries or something like that, so he protects everywhere. But if we say the car battery, then he confined himself to a car battery with that electrolyte. So this thing, basically, I'm trying to draw this picture just to have an idea that this is entire perception that where we focus our invention. The inventor has created something. So there are many different components in this car, and each component have its own structure, its own functioning. Let's say, for example, there are tires. So the tires, if we say a compound has been developed for which is very durable compound for the preparation of the tire. So again, the same question, if we say that tire of a car may be claimed, or a compound used to prepare tire of a car may be claimed. So rather than if we claim a compound for the preparation of the tire, leave the preparation of a tire as a separate thing, just focus on the compound. So that compound may be useful in the preparation of many other things apart from the tire. So this thing has to be understood by the inventor and the drafter, and this is the most important crux or most important part of this entire patenting, the technological aspect of the patenting. And if anyone could correlate why that just 1 minute clip was shown, because it leads from a very nanomolecule level to the cosmic level, and it totally depends upon your perspective, where you look at and where you focus on. The invention may be a smaller invention, may be added to the car, but that doesn't qualifies to the inventor to claim a car, because it has many other inventions which are being added to that simultaneously. So it is always best that to first of all claim your core thing which has been invented, where the modification has been done. So if the modification has been done in the battery, the structure of battery, you can claim the car battery, or rather, instead of a car battery saying it as a car battery, say it is a battery, a power source with this arrangement. So that power source can then be open, even if it is used in a bus, truck, car, or home, or something like that, that is protected. So that has to be seen, because many times the core inventor are not able to identify this smaller issues. How much time is left with me? I think I'm running out of time a bit.
Yeah, maybe you could, yeah, this could be your presentation. I mean, you can probably continue with this, maybe another 5 minutes or so.
Okay. I'll try to summarize the things in next 5 minutes or 5 or 10 minutes, right? So basically, I have asked the key question to my audiences, that how the things has to be seen. It's totally depend upon the perception, our perception, where we look at the things, and how we are able to pinpointedly identify the core invention, where the invention reside, and that has to be clearly brought into the entire document, our claims, our description. If we do not fail to do so, the things would be lost somewhere. The core invention would not be visible to the other party. If we incorrectly identify this perception or the scope, what we are trying to claim or what we have done. So that is very important. So these, again, there are claim format and other formal things which can be just gone through and accordingly identified. So basically, I will just take another 5 minutes to quickly summarize the parts of claim. The claims have preamble, transition phrase, and the body. So the preamble, I was talking about just a few words of the starting words. The name defines or describes the subject matter of the invention and state an intended use or purpose. The transitions joins the preamble with the body and affects the scope of the claim. Body recites element steps of the claimed invention and how they are interacted with the other parts. So basically, the preamble means we try to give what we are trying to protect. We are trying to say a device, a electrolyte. So that gives a preamble. Comprising, consisting, including, all these are transition phase, and these will decide upon the scope. If we are saying comprising, or we are saying consisting, although language wise they may not seem very much different, or they may be linguistically having the same meaning, but when these are identified legally, they have different meanings. The consisting mean it consists only of what has been subsequently defined, consisting 1, 2, 3, 4. So it only have 1, 2, 3, 4. But when we use it comprises or comprising, so it means that it may have 1, 2, 3, 4, and there may be certain other things. So that's how we interpret it. So using of these transition verbs makes a difference in the entire claim structuring, and that's the relevance of these things in claim language. The body, the elements, recite all the elements. Now we were just example the electrolyte for a battery. So what all element or what all constraint has been added to that electrolyte, which has been used to manufacture that electrolyte. So those must be clearly given. They may be broadly identified initially. Maybe like if we say that if a organic solvent is required, so we may say it as an organic solvent rather than giving a specific name of a specific organic solvent. Subsequently, we may identify what all organic solvents has been used for that. This is just for means understanding how do we bifurcate the claim structure. These are again some examples we just discussed. Another important things in the claims that the proper antecedent basis should be there. That is, the use of indefinite articles a and n when introducing an element for the first time, and use of definite articles, that is the and or said, when referring back to the introduced element. And whenever the new element is introduced, it should be introduced by giving seeking a clear indication that it has been already referred to in the previous claim, because many times there's a claim structuring where is one independent claim and subsequently multiple dependent claims are there. So in the dependent claim, if we try to introduce any new element, we try to define it, so that should be broadly present there in the main claim. That should be care should be taken on that part, because if we introduce altogether a new element, that is considered as it is introduced, like it further comprises or it further consists. So we use those expression. But in the Indian patent practice, even the using of these expression is not preferred and is usually objected to. So it is always advisable to introduce only a restrictive part or restrictive element to already element which is already defined in the main claim or the preceding claim, in that way. So apart from that, we must always focus the drafting part with respect to the other legal requirement, that is the requirement to comply with the novelty, inventive step, and non-patentability. That should always be borne in the mind, that if we are drafting a patent application which is related to a method of treatment, maybe a device for the treatment of this. So instead of claiming a device, we say a method of treating a cancer using this particular device. So because method of treatment is non-patentable subject matter, the entire invention will be destroyed by that kind of expressions. So we must always be aware of what are the things which are required, what are the things which are non-patentable. So that should be taken into account while drafting things. The things may be redrafted, rephrased, depending upon the things, but it has to be known to the drafter or the inventor. So there are different exclusions which are being there in the section 3, non-patentable subject matter, and these are listed from 3A to 3J and all those things. 3B, commercial exploitation, and all these example. 3C, mere discovery of new living things, discovery of non-living substances, and 3D, which is most common or hindrance which we find nowadays. Of course, there's a way to it, and to overcome this particular application of this non-patentability clause, but that has to be kept in mind, and the relevant data should be provided in the description so as to comply and to overcome this particular non-patentability issue. So likewise, all these non-patentability should be kept in mind while drafting a proper patent applications. So with that, I just conclude this session with small questionnaire, which I'm just sharing my screen for that reason.
Have you shared the screen, Dr. Deepak? Dr. Pradeep? Yeah, it's
Yes, yes. Yeah. So I would be sharing these things, and meanwhile they can have a note of it. Basically, these are some questions, simple questions based upon the this thing.
So this goes as some kind of an assessment, assignment also. Can they just work on
Yes,
this and come
yes.
back?
So yes, this is just a true and false, and I think one is that optional question, that MCQ kind of thing. So the participant can just make a screenshot of it.
Shared with our team, Dr. Anchal. Has this assignment been shared, or is it just now that we have this assessment question?
I think I have sent an email, but that has not been through our server. I think that's an issue. So
Okay.
yeah,
Because we are running out of time and we have a session just coming up immediately.
yes.
Wind this up. Would it be possible for you to share this document over an email with Dr. Anchal or something of that sort?
Okay. I do that.
we can get the responses from the participants and we can submit them to you.
Sure, definitely that would be a great idea. Yeah,
Okay, bye.
I do that.
Yeah.
So with that hope, the participant have got some insight about how to work around with the techno-legal aspect of this specification. And with that, I thank you, the organizers, especially Dr. Pratima. There.
And should our participants have any questions, please feel free to write to us and we will forward these questions to Dr. Pradeep. And Dr. Pradeep will be happy to share his responses and queries on the subject.
Sure, definitely.
Thank you so much. This was a very, very informative, fantastic session post lunch, and I think every minute of it was a learning for all of us. Thank you so much, Dr. Pradeep, and we will touch base with you with responses as well as questions, if any.
Yeah, thank you, Dr. Pratima. I hope
you.
I justified, and because of his post lunch session, I don't know how many of I am able to keep them awake.
Perfectly. No, very, there was a lot of learning through the session. So went very well, quite an interactive one. Thank you.
Right. Thank you.